as I mentioned, my name is Erin Choquette. I'm the General Counsel for the Connecticut Paid Leave Authority. I am an employer side lawyer by training and practice. For the past 20 plus years, I've really been on management side, but I don't really think there's an employer side versus employee side with FMLA. I think we all need to understand what's going on and how to comply with the laws. So that's the focus for today. We're going to talk about the Connecticut Paid Leave Program and sort of what the authority is and who we are. And then we'll really focus on making sure that everyone understands the two laws that are at issue here. One is FMLA and the other is CTPL. So I'll define those acronyms and then we'll talk about how they'll be implemented. I'll share with you some resources that we have available to you. And then there will be time at the end to go through the questions that you present through the Q&A function. All right, let's talk a little bit about the Connecticut Paid Leave Authority. We are a quasi-public agency, which means that we are a public entity, but we're not a traditional state agency. We have a little bit more flexibility. We're a little bit more nimble, which is really important because we were given a lot to do in a very short amount of time. So we have to set up a program to make sure that individuals who are out of work for covered reasons are able to receive income replacement benefits. So they don't have to worry about choosing between caring for themselves or a family member and putting food on the table and a roof over the head. So our primary mission is to provide that accessible pathway to benefits, but we think it is equally important to make sure that employers, administrators, healthcare providers, really everybody involved in the process understands their roles and are able to fulfill their responsibilities. We don't want to leave anybody out in the cold. So at the authority, we have several statutory requirements, including outreach and engagement. So we really do focus on education. If you haven't checked out our website, please check it out. We've got a lot of information there for you. We have newsletters that you can sign up for, and we do webinars like this one. We had to start from scratch. So we've been building the authority as we've been building the program. And one of that responsibilities is creating our policies and procedures. We don't have regulations. We have policies and procedures that are adopted by our board after public notice. If you're interested in seeing our policies, you can email us and we'll give you copies. Whoops, I apologize. I thought I had turned off my notifications. So we're just setting up policies and procedures needed to run the Connecticut Paid Leave Program. We also have a statutory responsibility of establishing the contribution rate and receiving contributions. Under the statute, the contribution rate can be no more than 0.5%, but in the future, if our trust fund has a nice solid reserve, we may be able to reduce that contribution rate. There is an alternate compliance method. So everyone is subject to the Connecticut Paid Leave Authority and the Connecticut Paid Leave requirements, but employers can submit applications to the authority saying, we have our own private plan that does everything you do, and we'd like to continue handling it ourselves. So if they apply to us and we approve it, their employees would not contribute to the paid leave program. They would receive their benefits through that private plan, and the authority would audit that to make sure that the employees are getting the benefits that they're entitled to. For everybody else, they come to the Connecticut Paid Leave Program for their benefits, and we will be administering those claims. We have contracted with a third-party claims administrator, AFLEC. You may have heard of them. They will be handling a lot of the day-to-day work to make sure that it goes smoothly and claims are processed quickly and the benefits are paid in a timely fashion. So it's a quick overview of the authority. As I said, we've been running pretty much nonstop. Our website went live in September of last year. In November of last year, we opened up the employer registration so that employers could register with us so that they could remit those contributions. Under the statute, the employees were responsible for contributing into the paid leave trust starting in January of 2021, and the employers needed a way of getting that money to the authority. So they need to do that by registering. We started receiving applications for private plans in February. We actually receive the contributions on a quarterly basis, and we do give a 1-month grace period. So we receive those. The first batch of contributions came in April 30th. Second batch came in July. We're expecting the third batch right about now. And the fourth batch will come in due at the end of the quarter, but with the grace period in January. We have been working very hard to make sure that we will be up and running for the claims administration. And in fact, we are going to be able to receive claims starting in December. So employees who want income replacement benefits from the authority can submit their applications to us starting in December. However, we will not approve any benefits until, we will not pay any benefits until January. So we're just getting a 1-month head start on benefits because the benefits will start being paid for absences on or after January 1st of 2022. Threshold question that I just want to kind of cover before we get into anything else is, who is subject to the Connecticut Paid Leave Act? Who is part of this program? The short answer is almost everybody. So by statute, an employer is covered if they have 1 or more people working in Connecticut. So that's pretty broad. It is broader than the statutes for unemployment insurance compensation, for example. We do include nonprofits. We also include private sector employers with unionized workforces. They are covered. Sole proprietors and self-employed individuals who choose to opt in can do so, but they're not required to participate. They have to choose to opt in. On the other hand, there are some entities that are excluded from participation. These are pretty much the same entities that are excluded from coverage under Connecticut FMLA. So there's some consistency there. So who's not covered? Well, the federal government, we can't tell them what to do. The state of Connecticut, except as to our covered public employees, which I'll define in a minute. Municipalities and local or regional boards of education are also excluded unless they have covered public employees. And non-public elementary and secondary schools are excluded from the program. So those are the entities that are listed in our statute as being excluded, but there are other laws that we have to take into consideration. And as a result of those other laws, there are some other entities that are exempted from the program. Railroad workers, for example, are subject to federal laws relating to their sick leave. So they're covered under the federal law. Employees who work for governments of other states or for other sovereign nations like Mashantucket, we as a state can't tell another sovereign what to do, so they're excluded. There are 2 tweaky little exceptions that I just want to flag for you. If you are an employee engaged in interstate commerce, and by which I really mean railroad or trucking, interstate trucking, and you work in Connecticut, but you live in another state, you are not subject to the income tax in Connecticut. Now, if you're an employer in this situation, you already know who these employees are because you're not remitting any Connecticut income tax for these employees. And under that same law, they would not be subject to the Connecticut Paid Leave Act either. Similarly, if you have an employee who is the spouse of an active duty military member who is stationed in Connecticut, but they have opted to continue paying taxes in their home state as opposed to here where they're currently deployed, you know who they are because they're not paying Connecticut taxes and they wouldn't pay the Connecticut Paid Leave contribution either. So covered public employees, who are they? Well, covered public employees are people who do participate in the paid leave program. We do remit contributions and we would be able to apply for benefits. And that includes non-unionized employees of the state of Connecticut. So managers, appointed officials, judges, legislators. Unionized employees of the state of Connecticut are excluded unless they collectively bargain to be included. So far, no one has done that. Employees of municipalities and employees of local or regional boards of education, either union or non-union, are excluded for now. But if their unionized employees collectively bargain to be included, then everybody comes in, union and non-union. We get a lot of questions about sole props and independent contractors. As I mentioned, they're not required to participate, but if they want to, they can be enrolled. But we get questions, well, who's a sole prop? Who's an independent contractor? The statute really defines that by how you pay your taxes. If you pay self-employment taxes, which is a term that's defined by the IRS, you are not an employee, and therefore you're not required to participate. But you can choose to enroll. If you enroll, you have to stay in for 3 years, and your contributions are based on 0.5% of your self-employment earnings. If you're a sole proprietor who also has employees, you do have to register with the Connecticut Paid Leave Authority, and you have to remit the contributions of your employees. So we want you to register as an employer because you have employees, even if you don't register as a sole prop for yourself. Another issue, sometimes sole proprietors or independent contractors set themselves up as employees of their own business for tax purposes. Well, if you have done that, you are receiving a W-2 from your business. Even if you're the owner, you have identified yourself as an employee, and therefore we consider you an employee as well, and you would have to participate in the program. Okay, so we've got through the threshold questions. Let's talk about the laws that really form the basis of what we're all going to be confronting starting in January, FMLA and CTPL. FMLA stands for Family and Medical Leave Act. But actually, there are two that we care about. There's the federal FMLA, and then there's also a Connecticut FMLA. Other states have their own FMLAs, but we're not going to worry about those. We're going to focus on federal and Connecticut. Both laws allow eligible employees to take job-protected time away from work. That's what they do. The employee has to take time off from work for one of these reasons. They're entitled to their job back at the end of their leave. Both laws state that the leave is unpaid, but that the employer may adopt policies to provide income replacement during the leave. So this may take the form of employers who just keep the employee on their payroll. Some employers do that. More often than not, however, you see employers either require or allow their employees to use their earned accruals, like their sick leave or vacation or PTO, while they're out on leave. Connecticut FMLA is going to change significantly in 2022, so we really want people to pay attention to those changes, because if you think, oh, I've never had to worry about that before, you probably do need to think about it now. How are they changing? Well, the first thing that's changing is who it applies to. Right now, Connecticut FMLA only applies to employers with 75 or more employees. So if you're small, you've never had to worry about them. Starting in January, Connecticut FMLA will apply to employers with 1 or more employees. The eligibility for leave is also changing. Right now, an employee has to have worked at least 12 months for the employer and have worked at least 1,000 hours in the 12 months immediately preceding when they started leave. So you basically don't get job protection until you've been working for 12 months, and you still have to show the 1,000 hours. Starting in January, the hours worked requirement goes away completely, and an employee can get job protection when they take leave after 3 months. The amount of leave is changing too. Right now, it's 16 weeks in a 24-month period, with 26 weeks available for something called military caregiver leave. Starting in January, it's going to switch to 12 weeks in a 12-month period. That 26 weeks of leave for military caregiver still exists, but it's going to be in a 12-month period. And there's also the ability to take 2 additional weeks of leave for an employee who has a serious health condition resulting in incapacitation during pregnancy. So they might get an extra 2 weeks. Finally, the rules about when an employer can require the employees to use their accrued time are changing. As I mentioned, the law says right now, an employer can require or permit an employee to use their PTO, and there's no limit. The employer could say, you have to exhaust all your time. But starting in January, there is a restriction. An employee who's taking Connecticut FMLA cannot be required to exhaust all of their PTO. You as the employer have to allow them to hold on to 2 weeks if that's what they choose to do. When this was being discussed in the legislature, there was a lot of discussion about people who had saved their time and their money, and they had a once in a lifetime cruise or trip to Disney in September, but then they got sick in March and they had to use up all their accruals, and so they weren't able to go on that trip. And the legislature said, okay, you should be able to hold on to 2 weeks for other purposes. FMLA. Then there's CTPL, Connecticut Paid Leave. This is a separate statute. It is it's related to FMLA, but separate. And we actually use CTPL to refer to the act, the program, as well as ourselves. But basically, when we're talking about the Connecticut Paid Leave Act, we're talking about the Connecticut law that creates a source of income replacement benefits. It does not provide job protection. A person who is getting benefits from Connecticut Paid Leave is not entitled to their job back. You might also hear about this as paid family medical leave or PFML. We really try and talk about CTPL just to reduce confusion between FMLA and CTPL. If you say PFML, people think FMLA. As I mentioned, Connecticut Paid Leave and FMLA are related, and one of the areas of overlap are the reasons that a person could take leave under FMLA or receive income replacement benefits under CTPL. You can take this time if you have to take time away from work to receive treatment or recover from your own serious health condition. And serious health condition does include pregnancy, as well as serving as an organ or bone marrow donor, as well as several other situations. We call this medical leave. You can take leave to care for a family member who has a serious health condition, which we refer to as caregiver leave. You can take leave to bond with a newborn or a newly placed adopted or foster child. We call this bonding leave. And bonding leave is available also for certain pre-placement activities, like having to go to court or DCF to meet up to finalize the arrangements for the adoption or the foster care. As I mentioned, there's something called military caregiver leave. This is leave to care for a family member who was injured on active duty in the military. There's also something called qualifying exigency leave, which is leave to attend to specific issues associated with a parent, spouse, or child's deployment in active duty. And finally, there's something called family violence leave. Now, family violence leave, the Family Violence Leave Act is actually separate from Connecticut FMLA. It's its own separate statute. It's been on the books since about 2012. And that statute says that an employee can take up to 12 unpaid days of job protected leave if they need to address specific issues relating to their experience of family violence. So to go to court, to relocate if that becomes necessary, to receive counseling. And under the Connecticut Paid Leave Act, we will provide income replacement benefits for absences related to those reasons as well. Now, caregiver leave. As I mentioned, it's available under Connecticut FMLA. It's available under federal FMLA. It's also something you can receive benefits for under Connecticut Paid Leave. But the scope of caregiver leave under Connecticut FMLA and Connecticut Paid Leave is broader than what it used to be under federal FMLA or the old Connecticut FMLA. Under federal FMLA and under the old Connecticut FMLA, you could only take caregiver leave to care for a parent or spouse or son or daughter who's under 18 or 18 and over, has a disability as defined under the ADA, which prevents them from engaging in 3 or more activities of daily living. So basically, very small set of people for whom you could be a caregiver. Under the new Connecticut FMLA, starting in January, and under Connecticut Paid Leave, caregiver leave is available for a parent or a spouse, a son or daughter of any age, as well as a sibling or grandparent or grandchild, or an individual related to the employee by blood or affinity whose close association is the equivalent of one of those parent, spouse, son, daughter, sibling, grandparent, grandchild relationships. Okay, so the people for whom you can take leave and receive benefits is a lot broader under the Connecticut laws. Now, this related by affinity has really resulted in a lot of questions because it's actually a new concept for Connecticut, although it's something that the federal government has been using for years in connection with things like bereavement leave, contractor sick leave, and the like. Basically, it's a recognition that families come in all shapes and sizes. They may not look like the Keatons from Family Ties or Ozzie and Harriet, from the Nelsons. It could be your chosen family. It's going to be a fact-specific situation where you need to understand, is there a significant personal bond, even if there's no legal or blood relationship? It could be the aunt or uncle who sort of stands in the role of a parent or a grandparent. I know in my own family, my great aunt came to every school event, came to every holiday. She didn't drive, so we did all her grocery shopping for her. And as she got older, we did all her laundry for her. And when she got sick, we took care of her. So in that situation, she's the equivalent of a grandmother. And I would, if she were alive now, I'd be able to take leave to care for her. Also, in Connecticut, we don't recognize common law marriage. So if you're not actually legally married with a ring and a marriage certificate, Connecticut doesn't recognize that. And under the old law, you wouldn't be able to take leave to care for your significant other. But under Connecticut FMLA, as of January, and under the Paid Leave Act, that unmarried significant other with whom the employee maintains a spouse-like relationship is family, even though they don't have a legal relationship. Okay, next couple of slides are just some kind of key takeaway slides for you, helpful to put up on your bulletin board if you like. Just summarizes some of the eligibility for the biggies: federal FMLA, Connecticut FMLA, and Connecticut paid leave. To be eligible for job protected leave under federal FMLA, first the employer has to have at least 50 employees. And the employee has to be employed by the employer for at least 12 months, and it has to have worked at least 1,250 hours in the 12 months immediately preceding leave. So very similar to the old Connecticut FMLA. But under the new Connecticut FMLA, job protected leave, the eligibility is just that you work for the employer for at least 3 months. For eligibility for paid leave benefits under Connecticut Paid Leave Act, we don't look at how long you've been employed. We look at how much money you've earned from one or more employees. So an employee who's earned at least $2,325 in their highest earning quarter, when we look at the first 4 of the 5 most recently completed quarters, will be eligible for paid leave benefits if they are currently employed in Connecticut, or if they're not employed in Connecticut, they had been during the past 12 weeks before applying for leave, or they're an enrolled sole prop or self-employed individual. So a person could have only worked for the employer for 2 weeks, and so they're not eligible for Connecticut FMLA, and certainly not eligible for federal FMLA, but they could be eligible for income replacement if they had earned enough in their previous job. Just a quick summary of the entitlements. You're really thinking 12. 12 is always going to be the right answer, almost always. 12 weeks in a 12-month period for federal FMLA, except for the 26 weeks for a military caregiver. 12 weeks in a 12-month period for Connecticut FMLA. 12 days can be used for family violence leave. And 12 weeks in a 12-month period in terms of income replacement benefits. Okay. We keep focusing on FMLA, Connecticut and federal, as well as Connecticut Paid Leave Act, because we're the Connecticut Paid Leave Authority, and those are really the primary laws that you're going to be thinking about. But you can't forget that there are other laws that may provide job protection or income replacement. Workers' comp technically is an income replacement benefit for covered on the job injuries and illnesses, but there is some element of job protection associated with that. Person who's receiving workers' comp benefits, however, is not going to be able to receive any Connecticut paid leave benefits. It's a one or the other. You can't get both. In terms of other job protection, you may have job protected leave as a reasonable accommodation under the Americans with Disabilities Act, the Pregnancy Disability Act, or the Connecticut Fair Employment Practices Act. So you just always want to be aware of those other entitlements when you're confronted with an employee who needs time off from work. So let's talk about implementation of the Connecticut Paid Leave Act and the Connecticut FMLA. I was just looking at the Q&As, but I think I'll save those to the end. So when we're talking about the Connecticut Paid Leave Act, there's two halves. First, there's contributions, and second, there's claims. In connection with contributions, the employee is responsible for contributing their wages, 1/2 of 1%, calculated the same way you calculate FICA, up to the Social Security contribution limit. The employer does not have an obligation to pay into the Connecticut Paid Leave Act, with one exception. And that exception is that if the employer does not fulfill its responsibility of deducting the employee's wages and remitting those contributions to the authority in a timely fashion, the employer may therefore assume that responsibility, because the workers have no way of remitting the contributions directly to us. The employer has to do it. And employers who fail to fill that part of their responsibility could find themselves on the hook for covering their employees' contributions and dealing with the tax consequences associated with it. Now, the Paid Leave Authority receives contributions. We make sure that there aren't any over or under payments, and we will impose penalties for non-compliance. We made the choice not to impose any penalties in this first year because we knew it was a brand new law and everyone was working to really understand their obligations. But starting in 2022, we will be imposing penalties for non-compliance over and above the fact that the employer will be responsible for paying the employees' contributions, which, had they done it in a timely fashion, would not have been their responsibility. So the Connecticut Department of Labor has no official responsibilities in connection with the contribution side, but they do have general authority over wage and hour issues, including employee deductions. And up until the end of September, Connecticut DOL allowed employers to take catch-up deductions if they were unable to get their payroll up and running to get the deductions in place on time. So up until the end of December, employers could take additional deductions to make sure that by the end of the year, they were caught up with their employees' deductions. That sort of general approval for those catch-up deductions has expired. So if you are an employer who had not done your deductions, you either have to pay for them yourself or submit a request to Connecticut DOL for permission on an individualized basis to take those additional deductions and have to justify why you weren't in compliance. So just what does this look like? The employees contribute 0.5% of their wages up to the Social Security max. The employer has to remit those contributions to the authority with some very minimal wage information. We receive that. The money goes straight into the Paid Leave Trust, which is a standalone account. It is not considered state money. It's administered by the Office of the State Treasurer, but cannot be used for any purposes other than administering the Connecticut Paid Leave Program and funding the benefits. So that's the contribution side. Hopefully you're all familiar with it because we've been 3/4 in by now. Then we have the claim side. Similar division. There are 4 roles, four entities that have a role. The worker is responsible for applying. If they want to receive benefits, they have to apply to us. They may have to create an account with us, which we'll walk them through. They'd have to provide supporting documentation, including giving us information about their absences and info about other sources of money. And by statute, they are required to notify their employer that they're making a claim with us. The employer has limited role in regard to these claims. They do have to complete an employment verification form for us. We may need them to validate absences and other sources of money, but that's about it. They do have to notify their employer if they have rules relating to when the employee can take paid time off, or if they have short-term disability policies. And of course, they can't discriminate or retaliate against an employee who's utilizing these benefits. The Paid Leave Authority, with our contractor AFLAC, will process the claims, including approving the benefits, denying it if it's appropriate, investigating fraud, and imposing penalties for fraud and other non-compliance. And the Connecticut Department of Labor is responsible for hearing appeals if we deny a claim or for imposing penalties. So what does this look like? Well, the worker submits the claim either by calling AFLAC or going onto ctpleave.org and clicking on the "Want to apply for a claim." They have to provide us with information about their claim and provide us with documentation to substantiate the claim. AFLAC will determine the eligibility, and if they're eligible, will, upon review of the documentation, approve or deny the claim. If the claim is approved, AFLAC will calculate the benefits, taking into consideration the employee's earnings as set forth in the statute, and will issue benefit payments. Payments will be issued either through electronic transfer or a stored value card, which is a debit card. They'll be issued, regularly speaking, they'll be issued on Tuesdays. We say 2 weeks in arrears. Technically, it's 10 days. So, for example, a person who's out the week of January 2nd through the 8th would be issued their benefits on the 18th, assuming their claim is completed in time. And then the worker will continue to keep us informed of any changes. If they need to be out longer, if they're back to work sooner, we only provide benefits for when they're not working. The the benefit amount is set forth by statute and is based on how much the worker earned in their base weekly earnings, which are, when you look at their highest 2 earning quarters in the first 4 of the 5 most recently completed quarters. If those base weekly earnings are less than or equal to the minimum wage times 40, the benefit will be 95% of that amount. If the base weekly earnings are more than the minimum wage times 40, they'll get 95% of 40 times the Connecticut minimum wage, plus 60% of the difference between their base weekly earnings and the Connecticut minimum wage multiplied by 40. However, in all circumstances, the benefits are capped at 60 times the Connecticut minimum wage. So just like the contributions were capped, so too are the benefits. So this slide just gives you sort of the math to show that someone who's earning $13 an hour, working 40 hours a week, would get 95% of that amount, which is $494. Whereas someone who's earning a little bit more, we still start with the 40 times the Connecticut minimum wage, 95% of that, plus 60% of the difference. So in this scenario, worker B earns $13.50 an hour, and therefore they'll receive $506 in benefits instead of $494. We get a lot of questions about the intersection of the Connecticut paid leave benefits and employer-provided benefits. Our statute says that an employee can receive both Connecticut paid leave benefits and employer-provided benefits at the same time, as long as the total amount does not exceed 100% of their wages. So we need to know from you, are you requiring or permitting your employees to use their paid time off? If the employee has no PTO or is choosing not to use it and you let that happen, they'll start receiving their Connecticut paid leave benefits when they go out. So for the full amount of their leave, it's covered by Connecticut paid leave. If you require your employees to use their paid time off and they have enough to cover their full amount of leave, they're not accessing their Connecticut paid leave benefits. They're just not touched. They're sort of held in reserve, and their full amount of leave is covered by their PTO. More often than not, you could see someone may have some PTO available to cover part of the leave, but not the full amount. So the CTPL benefits would start once they've gone through their PTO benefits, noting the 2 weeks that have to be held in reserve under FMLA. And then there's a situation where the PTO is less than the worker's regular pay. So maybe you only provide 60%. We'll be paying the benefits, you'll be paying benefits, and we have to coordinate to make sure that the employee does not receive more than 100%. So what do your workers need to know? Well, they need to know if you're going to require or permit them to use their PTO while they're out on leave. If you're worried about stacking, if you're worried about employees taking their FMLA leave and then taking additional time because they've got 6 weeks of PTO, you may want to require them to use their PTO while they're out on leave so that their FMLA and their PTO are running concurrently instead of stacked up on top of each other. But that's up to you. That's your decision. You just need to let the employee know, and you need to let them know if there are any rules. Can they use their sick leave for caregiver? Does it have to be their own serious health condition? And if you have short-term disability insurance, you need to know and let your employees know what that policy says. Most of them say that they're the payer of last resort, but not all of them do. And some of them say they'll offset. So you need to know what your policy says so you can tell your employee. All right, let's talk about FMLA. FMLA is job protected leave. The worker is responsible for notifying the employer, that's you, that they need time away from work and comply with your policies relating to leave. So you, as a employer, have to establish your leave policies, including policies about PTO usage. If you've got at least 50 employees, you have to post your federal FMLA poster, and you're responsible for processing the leave requests, monitoring leave usage, managing the employee's return to work, and of course, refraining from discrimination. The Paid Leave Authority has no official responsibilities about FMLA, but we do have learned that it's hard to train about Connecticut paid leave without explaining FMLA, so that's what we're talking about today. Connecticut DOL, on the other hand, is responsible for enforcing Connecticut FMLA. They will be promulgating updated regulations regarding Connecticut FMLA and providing guidance. And they also investigate complaints filed by employees relating to denials of FMLA, as well as discrimination and retaliation on the basis of FMLA usage. So what does this look like? Well, the worker notifies the employer they need time off from work. They don't have to say FMLA. They just have to give you enough information for you to know that this sounds like one of those leave reasons. They should tell you 30 days in advance if the need for leave is foreseeable, or as soon as practicable if it's not foreseeable. You, as the employer, have to determine if the worker is eligible under Connecticut FMLA or any of those other laws that I mentioned. And you would notify the employee if they have to give you any additional documentation. Now, eligibility is just, for Connecticut FMLA, have you worked for me for 3 months? You have to notify them if they're eligible within 5 business days of them telling you that they need time off. You also have to give them something called a Notice of Rights and Responsibilities. The Connecticut DOL is updating this form, and that form should be available to you within the next month. This is not leave approval. This is just, yep, you've got the ticket to enter. You have to tell the employee what documentation they need to provide to you. And the documentation really depends on the nature of the leave. And they have at least 15 calendar days to give it back. But if they tell you that they're having trouble getting the documents from their doctor or the adoption agency or wherever, you are required to give them more time. You need to be reasonable and work with them. Once you've received the documentation, you have 5 business days to let the employee know if the leave is approved under Connecticut FMLA or any of those other statutes. And when you approve the leave, you have to tell them if they have to use their PTO, if they have to report in, if you need a fitness for duty, you need to let them know what the expectations are. If they've done this all in advance, so they had a foreseeable leave, they told you 30 days in advance, all of this is done even before they go out. So when they actually do get sick or have the baby, they have to tell you that, okay, this is it. This is my FMLA. And then you have to track their leave usage because you want to make sure they're not exceeding the 12 weeks. And then, because this is job protected leave, the employer has to return the worker to their job. It has to be the same job, same terms and conditions. You can't switch them to a third shift because you found somebody better. And you have to make sure you comply with the ADA and CFIPA relating to bringing them back and not saying you have to stay home until you're 100%. So, all right, this isn't necessarily easy, but if you're organized and you really focus on the details, you can do this. You want to make sure that you have good, strong policies and enforce them. So enforce your attendance policies, enforce your call-in policies, make sure you know when your employees are out of work. If the absence is for their own serious health condition or caregiver leave, you can ask for the medical certification and you want it to be complete. Don't just accept a scribbled piece of paper. Now, intermittent leave can be challenging. Intermittent leave is when an employee has one reason for leave. Say they've got Crohn's disease. but they need to be absent when their disease flares up. So you don't always know when it's going to flare up. Flare-ups could be 2 to 3 days long, but only happen once every 3 months. You get that information from the MedCert, and then you have to work with the employee to try to manage it. What are you going to do? You may not know what's going to happen, so you want to plan for that. If you have employees who work overtime, you do have to account for that. That's what I mean by a fluctuating work week. When we're talking about 12 weeks in a 12-month period, it's based on the employee's average work week. So if you've got overtime, you have to account for that. But if they can't work overtime because of their condition, the hours they're not working would also draw down off their 12 weeks. As I've mentioned, don't forget about the other laws, but you should know an employee cannot say, oh, don't call this FMLA. I want to save my FMLA for something else. In all circumstances, it is the employer's right and responsibility to designate time off that qualifies under FMLA as FMLA, even if the employee says no. That's a way to manage the time and make sure that they're getting the 12 weeks they're entitled to, but that that's not getting extended by kind of off the books time. Giving you a lot of information, and I do want to get to those questions, but let me just tell you that if you go to ctpleave.org, we have tons of information for you. We've got toolkits, we've got posters, we've got fact sheets, we've got videos. So check us out. We don't want you to have to do this on your own, and we want to make sure that you know and your employees know what their rights and responsibilities are. So we've given you sort of various pieces of documents that you can share with your employees and you can review yourselves to make it easier. You can also check us out on YouTube. We've got plenty of videos online. Or you can go to our website and check out our frequently asked questions. If you still have questions that aren't answered, there's a contact us button on the website. We ask you to click on that, submit your question, tell us if you want an email back or a phone call back, and we will respond to you. We are not able to have a fully staffed call center. Our focus is on making sure as much money as possible, frankly, is available for the benefits. And staffing a call center is incredibly expensive. So we have this contact center, but we will call you if that's what you would like in terms of a callback. All right, so let me go. Oh, before I do this, ctpleave.org. Bookmark it, make it a favorite. All right. Question came in. If and when I have an employee beside myself, how far ahead of hiring this employee do I need to start paying into CTPL? You don't need to pay in ahead of time. If you don't have any employees right now and you are not enrolled yourself, you have no obligation. But as soon as the employee is hired, with that first paycheck, you need to deduct the 0.5%, and on the quarterly basis, you'll be remitting that employee's deductions. In 2022, job protection for Connecticut FMLA begins after 90 days of service. Does this mean that they're eligible for Connecticut FMLA from day one? Interesting question. So they're eligible for job protected leave after the 3 months. They are protected from discrimination or retaliation on the basis of asking questions about their FMLA from day one, but they don't get job protection. They can't get leave until they've been with you for 3 months. If an employee does not already have 2 weeks of PTO left when they take the leave, does that mean that the employee would automatically not be required to use any additional PTO? Yes, that is exactly what that means. If an employee goes out on FMLA for pregnancy in December, do the current laws apply or do the new laws apply once January comes? I'm just realizing that I'm sharing, so let me stop sharing. Great question. So an employee who's out on FMLA in December is going to most likely, particularly for a pregnancy, most likely carry their leave out continuing into January. So the Connecticut Department of Labor has on their website a guidance of how to handle that. And basically they say you can look back 12 months and see if they've taken any time in that 12 months, and you subtract that time from the time that they get in 2022. Now, I want to let you know that a person who's out on FMLA in December can't get can't get income replacement benefits from the authority for that time in December, but they could apply to us and start getting benefits from us for income replacement starting in January. Which raises this question: does Connecticut FMLA run concurrently with Connecticut paid leave? Maybe. If the employee is eligible for both and they have no PTO or they're not being required to use it, they may get their income replacement benefits from us as of the first day that they go out on leave. But if the employer says, you know what, I want you to use your PTO first and draw that down, they wouldn't start getting benefits from the Connecticut Paid Leave Act until that PTO gets to that 2-week part, 2 weeks in reserve marker. And so they would be a little bit off kilter. Question looks like an employee who must work for the state, because they're asking about the state manager's sick leave bank. And they're also asking about short-term disability. Would this be additional income that needs to be reported? So with short-term disability, it depends on who owns the policy. If you own the policy as the employee, you're paying for it, that would not affect your benefits under the Connecticut Paid Leave Act. That's just supplemental to you. With regard to the sick leave bank, that's considered PTO. And so if you are accessing the sick leave bank and you're receiving the PTO from the sick leave bank, then that would be something we'd have to look to make sure that the benefits from the sick leave bank, which are usually 50%, plus the benefits from the authority do not exceed 100%. Question came in: how many employees do you need in order for them to use FMLA? Well, for federal FMLA, an employer has to have 50 employees. For Connecticut FMLA, you have to have 1 or more employees. So if you have 1 employee and you're working in Connecticut, that employee is, you are a covered employer for purposes of FMLA, and that employee could take Connecticut FMLA leave after 3 months. New question: in terms of PTO, if we differentiate between sick leave, vacation leave, and PL, are we able to require them to exhaust all 3 categories except for the last 2 weeks, or can we only require them to use sick leave? Great question. So the Connecticut Department of Labor is in the process of finalizing the regulations to answer this. So I can't give you an official answer, but it's my understanding that they're basically saying you need to let the person have 2 weeks total, not 2 weeks in each category. But we'll have to see what DOL says in their final regulations. So question came in about basically if you were out on Connecticut FMLA in the past, which was 16 weeks in a 2-year period, what does that mean for people who want to take Connecticut FMLA starting in 2022? And as I mentioned, the Connecticut DOL does have guidance, and basically they're going to make sure that people don't get a windfall because the statute changed. So if you go to ct.gov/DOL, click on their FMLA button, that guidance pops right up. If an employer has a third-party administrator administrating leaves, is that third party responsible for notifying the employee if the leave is approved? Yeah, if you're an employer and you've contracted with a third-party administrator, the third-party administrator is acting as your agent. So you can say to the employee, our process is you have to work with them and they handle all of the responsibilities of the employer. Legally, the employer is still the principal and legally responsible, but they're delegated that responsibility to their agent. If we fall under federal FMLA, do we have to provide both federal FMLA and Connecticut FMLA, or just a Connecticut FMLA because it's more generous? You have to do both. So if you have 50 or more employees and you have employees in Connecticut, you are subject to both federal FMLA and Connecticut FMLA, which means you need to pay attention to your employees' entitlements for purposes of federal FMLA. Are they eligible, and is the leave reason covered? In Connecticut FMLA, are they eligible, and is the leave reason covered? If they're eligible for both and the leave reason for both is covered, that'll be a federal state combo. If they're eligible just for Connecticut but not for federal, the Connecticut FMLA will kick in first, and they'll have federal FMLA once they become eligible for that. So you do need to pay attention to both. Question about how much we're paying Aflac. So yeah, if our contract is public, if you want to, I don't have the numbers in my head, but if you want to submit a request to Connecticut Paid Leave, we can give you a copy of the contract. All that is public information under the Freedom of Information Act. We can tell you that we did a cost benefit analysis in terms of trying to build this all in-house and what that would do in terms of cost, in terms of risk, in terms of likelihood of getting this up and running on time. And on all fronts, it was much better and more efficient and less costly and less risk to go with a contract with Aflac. If an employee takes multiple Connecticut paid leaves, who tracks that time to make sure the employee is not paid more than 12 weeks in the year? Okay, so they would not be taking leaves from us. They'd be taking leaves under their leave entitlement, but they'd be applying to us for benefits, and we are tracking. So an employee would apply to us and say, I'm going to be out for 3 weeks and I need income replacement for those 3 weeks in January. Then they come back in March and say, well, now I'm going to be out for 2 weeks. We're paying attention. We're tracking all of that through our claims system to make sure that they don't exceed the 12 weeks in their 12-month period. We front our PTO, but normally account accrued time once the employee is going out on leave. Is the 2 weeks based on the time they will have once they return or the time they have before they go out? That is a great, really detailed question that is going to have to be answered by Connecticut DOL, because I don't have the authority to make that distinction. So when the DOL regulations come out, we'll see if they address that. If an employee is on leave for 12 weeks, can I hire someone to fill in and then with that employee be able to get unemployment once my original employee comes back? Great question. So the statute says that if you are an employer and you have to hire someone to fill in because you've got an employee who's out on leave and you let the fill-in person go, that is a non-charge to you for purposes of unemployment. So you won't get hit with that unemployment charge because you had to let that second person go. All right, I think I got through all of the questions that were open in the Q&A. Amber, is there anything that I missed?
I don't think so. I think you covered just about everything. For the folks that are asking if you're going to receive a copy of the presentation deck, yes, you will. I'll be sending that to you within the next couple of days.
Okay, so as I mentioned in the beginning, we really can't track the questions that are in the chat. So in the last few minutes, if you want to transfer any questions you have over to Q&A, I can look at those. And while we're waiting to see if anyone wants to do that, let me remind you again, check out our website, ctpleave.org. We're updating it almost all the time. I feel like every time I turn around, we've got a new release, including a new page for dedicated to small businesses, but it's information really everybody would be interested in, I think. There's a page relating to preparing to file a claim. And there is a HR toolkit. There's a small business toolkit. So there's a lot of really great information and resources on ctpleave.org. So please do check that out. We will be offering additional webinars. We have this webinar, which is really focused for businesses. We have a similar webinar, a lot of the same content, but similar for HR. And then starting next week, we'll be doing webinars that are geared more toward workers. So a little bit more of a, I'm an employee, what should I know kind of focus, and those will be coming up. You can find information about all of those webinars on our website. In addition, we have partnered with the Connecticut Small Business CBDC, Small Business Development Corporation, which is a great resource that is funded by grants from the Small Business Administration, DECD, and UConn. And they help small businesses in a variety of areas. And they are doing some webinars and providing some resources to employers to help them think about the impact on operations and how to plan now to prepare for your obligations under FMLA. Not the technical legal stuff that I'm talking about, more of the operational stuff. So check that out. Couple of questions that came in just in the last few minutes. How does the employer know if the time is approved? So again, if it's FMLA, you know, because you are approving it. If it's paid leave benefits, we will be issuing a notice to the employer saying such and such employee has applied for paid leave benefits for X amount of time. It's a block leave or intermittent leave. And right now, the plan is to provide sort of just a statement about the weekly benefits. That's still, we're finalizing exactly what that looks like, but we will be issuing that. And the employment verification form, it is mostly final. There is some, we're doing some last minute tweaking to see, we know that there are some things we've heard since we went public with it that people would like it to be changed. So we're trying to decide right now if we can make those changes right away, or if we need to kind of wait, see how it works out. So it's mostly final, but might be revised is the best I can tell you right now. You will see on the employment verification form that we ask for a contact person and a preferred method of communication, so that if they want to be emailed or have notices mailed to them, we will follow whatever the employer says on that employment verification. Okay, one last question. I know you've already covered this, but please clarify. I have an employee who's currently on a maternity leave, and I have considered her leave under Connecticut FMLA. She's entitled to 16 weeks of leave. Under new Connecticut FMLA, she'd only get 12 weeks. How do I manage this? Is it grandfathered? And so the best thing I can do, because it's really hard to summarize, is to tell you to go to Connecticut DOL's website. So ct.gov/DOL, and on their screen, if you scroll down on the right-hand side, you'll see family medical leave. If you click on that, they've got a guidance for specifically how to handle this with examples. So check that out. Connecticut state employees, are you getting a specific information? I can tell you I have promised to give a training class to Connecticut agency HR because it does affect Connecticut slightly differently. Unionized state employees are excluded from participation in the Connecticut paid leave program, so they would not get benefits from us, but non-union employees do. So I have training that we're trying to get scheduled for the Connecticut HR folks. So if you're interested, stay tuned. Is there a minimum amount of days to file a claim? No, there's not. So if it has to, they have to have a serious health condition as defined by the statute, but you could have a serious health condition, for example, that's sporadic. And so maybe your flare-up only puts you out for an hour or two. That would be sufficient. The FMLA does say that employers can say, we're going to count it anything at like 15 minutes. Anything less than 15 minutes, we're going to count as 15 minutes, but that's really the minimum. All right, we are now at 2:01, and you've been really great, so I don't want to take up more of your time. But if you do have additional questions, check out our website, use the Contact Us feature, and as Amber has shared with you, the DOL link, and we will be sharing the slides and the video. So I hope that you found this useful, and I hope you all have a good day. It looks like at least the weather in Connecticut is getting slightly better, so I hope everyone has a better afternoon. Thank you.